Well, hello and welcome to another edition of John's Rants. I'm John Giardinelli. I'm Association Counsel, and today's topic is going to be some of the new laws that are being has been passed by the legislature that will go into effect on January the 1st or thereabouts. Last month, we covered the new rent control law. I'll mention a few things about it today, but mostly we're going to cover everything else. So just understand that there were over 800 new laws that have been passed and signed into law by Governor Newsom. There were over 3,000 bills that were originally proposed. Some of them were consolidated, some of them were declined, some of them will come back this coming year. It's been a very active legislative year. So I'm going to cover what I think are important issues for either the realtors themselves or brokerages. First of all, probably the single most important piece of legislation is AB 5. This is the bill that will pretty much ban Uber, Lyft, and other drivers from being independent contractors. The good news is, thanks to the incredible work of your lobbyist, real estate licensees were carved out. Under the current law, as it will go into effect on January the 1st, if you are a person with a real estate license who has a signed contract with the broker or brokerage and is paid on a commission, you will be an independent contractor. That being the case, the test to determine whether the broker is converting you into an employment agreement as opposed to an independent contractor agreement will be based on an old case called Barillo. It's a very complicated 16-part test that most realtors will have no trouble meeting. The good news for the industry, I believe, and for brokers is that it's not considered control under the law if a broker requires the agent to attend training because the broker has a duty to supervise, and as a result, requiring training, particularly in areas of discrimination, the RPA, and things of that nature that go to the core of what the real estate professional does, will not be deemed to be controlling, which would take it out of the independent contractor status. However, a lot of other businesses are going to no longer be independent contractors or will have to meet strict requirements. So if you are involved with people that are in other industries that used to be considered independent contractor, you might want to have them take a look at this law. As I mentioned last month, AB 1482, which is the rent cap and just cause eviction statute, goes into effect on January the 1st. You can take a look at last month's rant. We broke most of that down, but as we're going through the statute in more detail, we're realizing that there are a lot of ambiguities and complexities. So we'll be doing more work on that statute, and as things roll out, what's important to remember is that you need to provide certain notices to all of your tenants by January 1st. The California Association of Realtors is coming out with some forms. Those forms contain the notices. So as soon as those forms are available in December, it's going to be important that you get that information to your clients. A couple of other laws that are going into effect. AB 1110 is rent noticing. If you are not covered by the rent control law, maybe the house is exempt, maybe there's some other reason, and you want to raise rents beyond what will be the rent cap, which is about 8% plus or minus, then you can raise rents how you see fit. However, if you raise the rent after January 1st by more than 10%, you must provide the tenant pardon me, with a 90-day notice. If you fail to do that, then the rent increase will not take effect. There are a number of bills, AB 68, 670, and 881, that deal with accessory dwelling units. It will put limits on what cities can require because of the affordable housing crisis. The city, for example, cannot make an owner live in one of the ADU units, cannot charge specific or substantial impact fees. There are some exceptions to that. HOAs must allow construction of ADUs within their boundaries. ADUs can also be developed at the same time that you're developing the primary unit. Cities are going to be prohibited from enforcing laws that currently exist against presently existing ADUs in order to allow them to become legalized, and cities must approve ADUs, and some of the approvals actually will be automatic if they're like garage conversions and things of that nature. So again, there may be some square footage issues, so you need to check the statute before you start construction. But it puts a lot of limits on cities to try and get some of these affordable housing units developed. And of course, some of the cities are pushing back. There's going to be an extension of a current law. Under current law, you cannot discriminate based on source of income. A single mom who's getting public assistance or child support, it doesn't matter where the money's coming from. If the person qualifies for the apartment based on the amount of money they have and otherwise qualify, you cannot discriminate based on source of income. Section 8 housing income is now going to be considered part of that source of income discrimination. So it prohibits discrimination against tenants who rely on that type of public assistance. That doesn't mean that they must be rented to. There may be other legitimate, objectively verifiable reasons, but it does prevent discrimination based on source of income. There will be a new California Consumer Privacy Act that goes into effect on January the 1st. The good news is the California Association of Realtors is coming out with a form in early December that is a Privacy Act advisory. And so be aware of that. My suggestion is, number one, that you, of course, read that form very carefully when it's available, which will be on zip forms fairly soon. And number two, that you provide that to your clients. It gives consumers information about what businesses can and cannot collect in terms of information. It indicates what the limitations are, how consumers can submit requests to businesses to take down information. It does include things like photographs and other records. MLSs are exempt for the first 3 years because MLSs by law must maintain information for 3 years. So let's talk about some other employment laws. SB 530 expands the time to bring a workplace into sexual harassment training compliance. You will now have until 2021. So December 31st of 20, you will have to have all of your sexual harassment training completed. If you did the training this year, you don't have to repeat it next year. You're good for the 2-year period. There's been an expansion of sexual harassment protections. That is AB 2770. The situation could be that I bring a claim of sexual harassment or I assist somebody, and now I'm being sued for defamation. So this provides additional protection for purported victims of sexual harassment by limiting liability for defamation. Employees who report sexual harassment based on any credible evidence and without any malice towards the person being accused are not going to be liable for any injuries. They're protected. Communications between victims and witnesses will be receiving additional protection, and that, of course, includes the employer. Employers are now permitted to disclose the determinations of a sexual harassment charge in job references. Fair housing extension is going to take place. The statute of limitations, it's called the SHARE Act, or the Stop Harassment and Reporting Extension, extends the deadline for filing unlawful harassment to 3 years. So while it won't be retroactive, it does provide that any claim made after January the 1st will be looked at under the 3-year statute. AB 51 is a bill that generally will curtail arbitration agreements in employment agreements. It provides that an employer may no longer require employees and applicants to waive rights, particularly rights that are carved out for in the Fair Housing Department or in the Labor Code. It adds statutory penalties for retaliation if an employee refuses to waive any rights that they have under the law. It bans most mandatory arbitration provisions in employment agreements, including manuals, and it prohibits provisions that require employees to waive any other rights that they might have. It's an act called the Crown Act. Prevents discrimination against employees based on certain enumerated physical characteristics, particularly hair texture and work styles. It seeks to create a more respectful environment for persons of color or others who have specific natural hair issues. We're recommending that you revise your employment manual, particularly the dress code policies. There is currently a law regarding providing a safe lactation accommodation for women who are having children. It now requires that you revise your employee handbook and that the accommodation space is now going to be expanded with some new requirements, including that the area have a refrigerator for refrigerating the extracted milk and for having running water. One of the concerns that employers should have is that there is a PAGA, or Private Attorney General, provision that would allow for the collection of attorney's fees. There are some changes to settlement agreements. It voids the no hire provisions in settlement agreements. Right now, if I settle a case with a former employee who's brought a claim, we can put a provision that they will not seek to be rehired for any reason. That will no longer be allowed. It will be void. And there would be other exceptions, including that when an employer determines that the individual is engaged in sexual harassment or assault, there will be some restrictions as to the secrecy of those settlement agreements. And it does not require the employer to rehire, only that there's that I'm not going to rehire you because of some legitimate non-discriminatory or retaliatory purpose. There is a change in the confidentiality clauses in SB 820, prohibits settlement agreements in a case where sexual harassment has been charged and or settled, and prevents a requirement that the person committing that act be kept confidential. Criminal background checks are being changed in SB 1412. Narrows the employer's ability to consider sealed or expunged convictions. So if a person has had a criminal conviction, but they've been successful in having that record either sealed or having that conviction expunged, it will limit the employer's ability to consider that in a background check. Paid family leave under SB 1123 will be expanded effective in 2021. Allows employees to collect leave for an expanded list of qualifying circumstances, such as going to a military ceremony or a briefing, or if there's been a change in child care arrangements or counseling or something along those lines. And so those changes are all going into effect. As I indicated, there are 800 laws. Clearly, the laws getting the most consideration are AB 5, the independent contractor law, and the rent cap law 1482. I also want to point out, and we're going to cover in the next rant, that the Department of Fair Housing is going to be issuing some new regulations that will be effective on January the 1st. It covers almost all real estate, any place where someone can sleep pretty much. It also covers all kinds of discrimination based on race, criminal background, Americans with disability, income. It expands greatly sexual harassment. and it expands a number of other areas and protections, primarily for tenants, employees, and others who could be discriminated against. I'll cover that next time. Until then, we will see you. I'm grateful for your viewing this, and let us know if there's anything specific that you want us to rant about. We're happy to do it. We'll do the research. We'll provide you information. We're going to be revisiting some topics we covered last year. Things are coming down the road, and there's going to just be a lot to deal with in 2020 and so forth. Until then, John Giardinelli, and thank you again for watching John's Rants. Good night.